we provide organisations with support on subject access requests, not only the legal framework policy, but also the redaction work. And one thing that we've certainly seen, I would say, over the last 3-4 months is bulk numbers of subject access requests coming to us, organisations coming to us and saying, we've got 40 or 50, how can you help us with that? And one could argue, why have you got 40 or 50? Why have you suddenly got a number of subject access requests that necessarily didn't exist in those numbers before? I think the 3 or 4-fold. Certainly we're seeing, Natalie, a lot of subject access requests from former employees or employees who are most probably at risk of redundancy. It's a tricky time for people, isn't it? People are on furlough or people are at risk. You know, I certainly know a colleague of mine, a friend of mine, ex-colleague of mine, friend of mine who's been at risk for 6 months. And clearly, if you're working that home environment, you're on that part furlough, you're on flexible furlough, you're really concerned about whether you have a job coming back to come back to at the end of furlough and at the end of the COVID-19 lockdown. So one is employment driven, and certainly the concerns around that. Secondly, I think it's about awareness, Natalie. I think people are now more aware of subject access requests because they've had 12 months of sitting in front of computers, and actually they've been able to do their own research. They've had more information sent to them, and certainly there's a greater awareness. And I think the third thing is that organisations have been focusing on different areas, and not incorrectly either. You know, for example, local authority colleagues were repurposed. A number of local authority colleagues were repurposed at the start of March last year. I can't believe it's 12 months since the start of lockdown this time. That they were repurposed. They were sent on task about checking up on vulnerable and elderly residents in their borough, for example. They were refocused on providing homeless accommodation. They were refocused on work related to setting up coronavirus support networks in the community. So, and as a result of that, the number of staff that were A, required to process subject access requests, and then B, for example, if you were just the front end, you were a small information governance team, you only had 3 people, of which 2 of which were sent on alternative tasks, i.e. supporting the local authorities' response to COVID-19. And therefore, most of the other organisations which you deal with in the council were therefore also supporting that COVID-19. All of a sudden, it'd be pointless sending out, I have had an FOI request, I've had a subject access request, I've had a request in for information, can you please provide that information? The answer is unlikely no, because 40 hours of the week, they're engaged in other activities. And as a result of that, a backlog has occurred, quite rightly so in some respects, and necessarily legally, you could say quite wrongly, because the law is quite clear in terms of the supplying subject access information within a month. So therefore, I think there is a glut of subject access requests sitting on people's desks, sitting in people's inboxes, which now have to be shifted. And now we're coming back to a degree of normality in those organisations. I think certainly we're now seeing the result of 12 months of not really tackling subject access requests, and that's not incorrectly. It's not correctly. I'm not making judgments on that. It's just the place we're in.
Yeah, definitely. I think that's is reflected in a lot of the work that we're doing and a lot of the inquiries that we have in. So thank you, Nigel. And to go back and to get a little bit deeper into something that you said about staff facing redundancy, and a lot of the access requests that we're getting at the moment are employment driven. So we could be talking about staff that have been employed for a really long time here. And some of the inquiries that we've had, and I'm sure others are seeing, we're talking about huge amounts of documents. And recently a subject access request unearthed 9,000 documents. And a question that I get on a lot of the courses that I run is that reasonable? You know, should we as a controller be expected to search 9,000 documents? What about manual files? And if we're talking about staff that have been employed by maybe a local authority for, 20 years, we're talking about an awful lot of data that could be sat around all over the place.
Yeah, the laws about reasonable and proportionality. So the response of the data controller is about what is reasonable and what is proportionate. The law is split into two areas. It's split into computer processing, information which is easily readily available by a search. For example, we use G drive. Go into G drive, you want to find a file. No longer you've got, you ask, I asked Natalie, Mel, where have I put that file? You go into the top, you search it instantly within seconds. You can find that file and you can be looking at it. And then, of course, there's manual data as well. And you talk about 9,000 records. Well, certainly in adult and social care records, so in adult and social care records, for example, a lot of the, and certainly medical records to a degree, a lot of the notes that are historical are handwritten notes. And therefore provide a challenge to organisations whether they have to supply them or not during the subject access request. And there was a great case called Erezra versus Welsh Ministers. The background to the case is quite simple. That Erezra was working for various NHS bodies in Wales, was subsequently dismissed at some point, and went back to the data controller. At the time, it was the NHS in Wales, asking for information that hadn't been supplied in the subject access request. And cutting a very long story short, the court, when it went to the High Court, the judge was quite clear that a data controller's responsibility is to make a reasonable and proportionate search, not only of computer records, but also those manual structured data. And the law goes back to 1984. The right to access goes back to the 1984 Data Protection Act. But at the time, in the 1984 Data Protection Act, the only thing that was included was a computerized records. Word processing, for example, word processing documents weren't deemed as computerized records in 1984 under the legislation. And so the challenge that you then have is that the introduction of the 1984 Act was predominantly based upon, one, the requirement to meet the European Council Charter, the Charter of 1981, which would, one, facilitate swift business across the world by computers, so that UK wouldn't be left behind, and two, to protect the data of individuals. And the key then, if you look at the legislation, if you look at Hansard, if you read the words of Leon Britton at the time, who was the Home Secretary, Leon Britton said, the reason why we're introducing the Data Protection Act and the 1984 Data Protection Act and the right to access is, one, that we wish to be able to trade with the rest of the world, and two, that we need to do as little as possible not to put an undue burden on data controllers. Now, some of us might sit there and say, well, surely it's about rights, it's about individual rights. Well, yeah. That came later in terms of the enshrinement of the right to access information, but certainly the intention of the lawmakers at the time was, and certainly of subsequent court decisions, has been that you must make a reasonable and proportionate search. So when we consider 9,000 documents, well, it's about the relevance of the search, isn't it? Let me give you one example of that, Natalie. I was DPO for an organisation which had a case of an employee who worked there 21 years, and was suspended. And at that point of suspension, a subject access request came in. The information governance manager at the time rang me up and said, Nigel, what do we do? Employee is suspended, subject to a report. That report will be finalised in 4 weeks, but the individual has put a subject access request in, requesting 21 years of information. And of course, my response back to the information governance manager was quite straightforward. Well, does he want 21 years information, or does he want 6 weeks? Does he want the investigation? Does he want information related to the report? Does he want information related to the ongoing investigation and why that person is suspended? And the answer was, well, actually, he only wants the information related to why that person is suspended. So then you think, wow, well, that's actually quite interesting, that actually I go back to the data subject and say, what is it you're actually after? Do you really want your training records? And what purpose does your training records serve for your subject access request? Would it be helpful if I just provide information related to the report? And the way that was solved, Natalie, was quite simply, went back to the individual and said, look, and the individual agreed, yeah, I actually only want the report. And the report would be finalised in 2 weeks. And we said, look, are you okay with waiting 2 weeks before the final report is published, then we'll provide you all that information. And the subject requester at the time said, yeah, that's fantastic. That's all I want. So I think data controllers can make it a bit easier for themselves in working with, a bit like FOI. In FOI, there is a right to work with the requester to provide them all possible service to enable their request to be met. And I think that certainly in subject access requests, we couldn't be scared. But let's look at the 9,000, actually. It depends really, doesn't it, on the context of the subject access request. If we look at the subject access request where someone's requesting when they were taken into care between the ages of 2 and 18, that's their life. So what's reasonable proportionate? Well, actually, it's their life. It's a story about how they spent time going through care homes, how they spent their time going through different families, how they spent their time being repatriated, how they spent their time meeting their estranged parents, for an example. I had one case that I dealt with about 18 months ago, and it was a very sad case. Some adult and children's services cases are quite sad because they relate a journey. And one of the things that came up was that the health visitor had gone around to house. Child who was 3 years old was in the house. Health visitor looks through letterbox. Mother drunk on sofa. And when the health visitor manages to climb through the window, well played health visitor, through the back of the house, mother says to child and health visitor, get effing child out of this house, or otherwise I will kill child and myself. So health visitor puts in action, takes the child to a place of safety. Place of safety then is foster care or a night for a safe house for that night, and then that child has a cycle of being in care for the rest of their lives. Now, of course, when it comes to a subject access request, you then have to balance up, for example, the rights of the mother who was still alive, and also then you have to balance up the rights of the individual knowing how that person ended up in care for the rest of their life. So it depends in those 9,000 documents in the context. Most public authorities do the right thing. That they will not actually require individuals, particularly around manual and unstructured data, to go and jump many hoops of that if they are actually telling a story of someone's life. So the 9,000 documents, so to answer your question about the 9,000 documents, it depends on the case. It depends on the relevance of the case. But I think controllers can work a lot harder with data subjects, that they can work with data subjects a lot harder in actually establishing what is it you really want here. And don't be scared. The law allows you to do that, and certainly the context allows you to do that. And having that relationship with the individual, because ultimately it is their data. And remember, we're talking about data here and not information. So one of the things that also gets lost, I think, in a lot of challenges that people have around subject access is that we're talking about personal data. But of course, that personal data has to have context in the individual. I mean, if, for example, that case that I mentioned about the child and the drunk mum, and if all of a sudden you redacted the hell out of that, so it didn't mean anything whatsoever, it didn't mean anything whatsoever to the data subject or the context, then it would be pretty pointless sending that back.
Yeah, for sure. And I think you made a really interesting point there, Nigel, that often we see controllers or organisations quite reluctant to try and narrow the scope of a subject access request. And I think there's some confusion in the guidance. And as you rightly pointed out and have nicely explained, it's perfectly reasonable to do so. And makes sense for us as controllers to be trying to narrow that request down. But you briefly touched on that. I'd just like to elaborate more on manual data. So maybe for the people that are listening, if you could give us an overview of what we mean by manual data, what is construed as manual data or structured data, and how the temp test fits into that, and how as controllers we can use that to our advantage.
Oh, the infamous temp test. Yeah, cool. So manual unstructured data. So going back, sorry, I'm a bit of a geek, but going back to the 1984 1984 1984 Act. I said that computerized data was only in scope and manual unstructured data was not in scope. But there were various numbers of acts of Parliament post the 1984 Act, one of which was the Access to Medical Reports Act, Access to Medical Records Act, which actually introduced manual reports into the rights to, and some of them are still in existence today. Now, the reason why the manual data wasn't included in the 1984 Act is a quirk is a quirk in the legislation, predominantly based upon that the government of the day felt that it was easier for people to abuse computerized data, i.e. have access to it, and therefore breach of confidentiality, than it would trawling through a huge number of paper files. So therefore the risks were higher in computerized data and lower in manual unstructured data. So therefore, or manual data, forget unstructured data for the time being for manual. So as a result of that, that's the reason, that was the government's reasons why it wasn't included within the 1984 Act. And it wasn't until really the 1995 directive, EU directive, and the 1998 Act that we actually see the involvement of manual unstructured data. Manual structured data is really, in simple terms, an organized filing system which can be found easy. So the information which is in scope for subject access request in terms of manual data is manual data which can be found easily with the same ease that you can search a computer to find the information. That's most probably the lay person's and the best way of describing it. Now, if, for an example, that you had 40,000 people's records which were stored in a secure unit, say, for example, at RAF Kemble Airfield in Gloucestershire, I know has a storage facility, and I know one client who does have 40,000 records stored in a secure storage area, and it was under lock and key, and it was 45 miles from the office, and it was not in a structured way, and it would take you a huge proportionate effort to actually find the information and for search the information requested. Now that clearly wouldn't be, one, reasonable, two, proportionate, and under the legislation it wouldn't actually be in scope in that. And you mentioned the temp test. Well, yes. The temp test is quite interesting. The temp test goes back to two things. It goes back to the determinant case, the best case, which is always brought up by A, data protection practitioners, and B, also brought up in courts that are considering subject access tests, are is the Durrant case. The Durrant case is really quite a narrow case. It was really more focused on an individual who was trying to find out information rather than personal data. And it hinged on, the Durrant case goes back to 2003, and it hinged on four bits of information contained in a manual file. Durrant had complained to the Financial Services Authority about Barclays Bank. Financial Services Authority ran off and did an investigation on Barclays Bank, and then Durrant decided to put a subject access request in, looking around for information related to the inquiry that was going on between the FSA and the Barclays Bank. And cutting a long story short, the judge at the time, Lord Justice Ord, who was chairing the bench of the Court of Appeal, ruled that actually, because someone's mere name was mentioned in a document, didn't necessarily give them the right of access, because the substance of the document was about an investigation into Barclays Bank, and the only reason that Durrant was mentioned is because he'd complained about them, which in logic seemed fairly straightforward. At the same time, the judge ruled on, in the 1999 Act, the term manual unstructured data. And of course, that threw up a huge amount of debate around, did it have to be indexed? Did it have to be easily found? Did it have to be in chronological format? Did it have to be in a way that anyone can find it? And the ICO in 2011 tried to provide some advice to data controllers, and it was quite straightforward. It was called the temp test. And I'll read it to you because it's quite interesting. And for those people who want to see it, if you Google temp test, the ICO's frequently asked questions of 2011, you'll find it. Is there any rule of thumb I can apply to establish whether I have a relevant filing system? So is your manual unstructured data in a relevant filing system? And here's your test, ladies and gents, that you can use. If you employed a temporary administrative assistant, brackets a temp, would they be able to extract specific information about individual from your manual records without any particular knowledge of your type of work or the documents you hold? The temp test assumes that the temp in question is reasonably competent, requiring only a short induction, explanation, or operating manual on the particular filing system in question for them to be able to use it. So in essence, the temp test is that if, for example, someone wants data which is residing in manual data, the fact is it easy to find? And that was reinforced recently in a court case at the Court of Appeal, which slipped through the radar, which was 12 months ago, called Dawson Damer versus Taylor Weising. It went to the Court of Appeal, and just to reinforce the temp test, and I'll read again from the judgment, that and it's talking once again about manual access, so some manual data and access to it. If access to the relevant data requires the use of trainees and skilled lawyers, turning pages of the files and reviewing material identified, that is a clear indication that the structure itself does not enable ready access to the data. And we're talking about 35 files here. In fact, 35 files were completely unstructured beyond their chronological compilation under the description Ulyss Trust, which is the case. And in the initial High Court case, the judge lost sight of the needs for the causative link between that criterion and the ease of the ease of the retrieval of the data. So in essence, and whilst again in that case, the temp test was actually enforced at the time by the judges in that case. So therefore, the temp test is a really good test for you to say, if we got a temp in from Goody Temps tomorrow, and we said, can you find information? If they had to leaf through 9,000 manual documents, which weren't indexed, which weren't easily available, and didn't have the right search that you would have on a computer basis, Natalie, then my view would be those documents would be out of scope.
Yeah, absolutely. Fantastic. Thank you very much, Nigel. I just want to highlight, I've had a couple of comments in the chat box as well, really sort of just adding on to what you said and highlighting that data, not documents approach. And as you mentioned, the mere mention of somebody's name doesn't automatically mean that it's their data. And they
and Natalie, a lot of people lose the plot with Durrant, and they lose the plot with Durrant because Durrant was only, and certainly in the EDAM case, which is a 2015 case, which is an FOI case, is that Durrant was only applied to a very narrow circumstance when Durrant's main interest was finding out about information, not about his personal data. He wanted to know who was dealing with the case with Barclays. It was nothing to do with him. It was actually a complaint about the way that Barclays had handled the complaint. And because his name was mentioned, he wanted to know the names of the individuals involved and what the FSA were getting up to. So in essence, he was using subject access requests like an FOI request. That's what he was doing, and so Durrant was very narrow in its interpretation of personal data, but it was very clear on its interpretation of manual filing systems and what is a relevant filing system.
Okay, so whilst we're on the subject, I think we're nicely covering the controller's obligations where subject access requests are considered at the moment, and the temp test being a fantastic tool for controllers. So what about third parties and where third parties are concerned? What are obligations of the controller and how does that affect the way that we process subject access requests?
So subject access request, repeat the question again, Nat, sorry. Sorry. Sorry, so I'm making the mistake of having the chat box open and reading some of the comments, which is not helpful. So I'm now going to close. I'm going to close the chat box because I shouldn't have done that. Sorry, Natalie, you crack on.
No, so I just mentioned that we've covered quite a lot of the obligations of the controller so far. So just to expand on that, what about third parties and the controller's obligations where third parties are concerned?
It's always a very challenging. You mean third parties mentioned in a subject access request? So for example, I see I've got my old friend Paul Byrne there on the line from Jersey. Welcome, Paul. So Paul puts in a subject access request, and your and our names are in that subject access request, and it's about releasing the information. Is that right? Yeah,
definitely. And to highlight and give you maybe an example, and as you say, I can see a couple of familiar names to myself as well from local authorities. And you mentioned earlier on social care records and healthcare records, and often they're quite intertwined. We could be talking about family data and siblings and, you know, known individuals. How do we address that, and where do you think the line is?
It's a very fine line, and particularly around adult and children's social care, and particularly around employment, and particularly around whistleblowing as well. Those are the challenges. What we must remember as practitioners, ladies and gentlemen, is not only do we have to have a knowledge of subject access request legislation around what I can release and what I can't release about third parties, but we also have the common law requirement and duty of confidentiality. So the common law duty of confidentiality means that you cannot share the information of a third party unless, one, you have a legal or regulated requirement to do so, and you're told by law you do. Two, you have the consent of the individual. Or three, there's substantial public interest. Wow, substantial public interest. That's where the interest of releasing the information relative or the data of the third party outweighs the information or retaining or redacting that information. I had a great case, Natalie. One of the great cases about that is a small organisation that we work with, a small committee, and someone had whistleblowed. And cutting a very long story short, because of the nature of the small committee, you can redact the names, but people knew who they were anyway. But someone had whistleblown around sexual harassment, around bullying, and of course, when the subject access request was sent back, although it was redacted, it was quite clear you could work out, you could identify individuals. So it's quite tricky. Also, you're in the scenario whereby in family circumstances, which might be family breakups, you might have an estranged parent asking information relative to the child. Well, ultimately, the information is the child's. It's the child's information. It's the child's personal data. It's not necessarily the adult in that case. And a lot of people band around about, well, that as long as they're 13, that sort of thing, it's their data and the parent has a right. Well, the parent necessarily doesn't have a right. You must remember your common law duty to that. And if you work in the healthcare field like I do sometimes, you're quite clear about the issues around, does the individual have capacity to understand and give consent, for example, for that information to be shared? So it's always very tricky on each individual subject access request to work out, one, who is in scope and who isn't in terms of third parties. Two, what is your common law duty of confidentiality in terms of it? And three, who you need to keep in and keep out. And the fourth thing, I think that I said this to you yesterday, didn't I, Natalie, about you can redact the hell out of a subject access request, but will it then be meaningful to the individual? Will the subject access request serve the purpose? Let's go back to the individual. Let's go back to the individual whose mother was lying on the on sofa drunk. You know, I redacted that. I did that. That was mine. That was my my balance, and I had to balance up. Well, the lad is actually asking why he was in care for all his life. And the cycle of care started that night, but the mother's still alive. So therefore, I have a common law duty to the mother. Are they on good terms? Are they on bad terms? If, for example, I release this information, would the son at some point, now being a grown man, go round and lamp the mother because of the events that happened that day? Do they have a good relationship at the moment? So there's no easy or right answer, but I think that you need to look at the context of which the application is made in terms of the subject access request, balance up the public interest of the third parties. You know, your default position is third parties are out. So that's your default position, and you work back from that information. And then the third thing is, if you are going to release the information, are you really sure that you want to release this information? And fourthly, would it materially alter the balance of the subject access request if you kept that information in or out? And I think those are the challenges you've got. Everyone's different, Natalie, and I think it's about the context of the subject access request.
Yeah, for sure. Thank you, Nigel. I think context being the main word there to highlight, and I'm sure for people that are familiar with us at DSAR and many other data protection specialists, it depends is a favourite phrase. And just to elaborate slightly, you said really we want as much information as possible, as you said. When you're talking about the children, do they know their mother? Is there a relationship? So at DPAS, when we're outsourcing redaction work, we have a suite of policies and templates, background information that we ask for to really try and establish that communication and get as much information as possible to provide more context, which obviously all feed into a SAR policy or a data protection policy. What do you think they're particularly important? And if you do, what do you think makes a good one?
So openness and transparency. A policy is about openness and transparency, and it's also a vehicle of which all people working for an organisation understand their obligations in terms of what subject access requests are all about, what do you do if you get one, and what's in scope and what's not in scope. And I remember about 2 years ago, I was running our DPO course, and we had 3 or 4 DPOs there, and they were saying, what do we need in a subject access request policy? Well, you need the basics. This is what a subject access request looks like. This is how staff will be trained. This is the process map of when a subject access request goes in. This is how we use an exemption. This is how we use, for example, some of the challenges that we might have around some of the contextual issues. This is who we go to, and this is ultimately who signs it off, and this is how we'll deliver it. But one of the key things that, a subject access request policy is openness and transparency to the subject access requesters about the systems and processes you will look into. What do I mean by that? Well, the best subject access request policy is the one that says, if we get a subject access request policy from an employee, for example, let's say an employee, for example, we have 3 systems which have 95% of all personal records kept on. 1, we have an HR system, which keeps your records on. 2, we have a payroll system. And 3, we have a training system. So therefore, if we get a subject access request into those systems, we believe as a data controller, it is reasonably proportionate to only search in those 3 systems. Any extension of those systems will require more detailed work, and therefore we might not. Now, you might include emails into that as well. It's entirely up to you. It's entirely up to you whether you do. But my advice to data controllers would be, in your subject access policy, my advice to you would be that you include the top 4 or 5 systems that you have information related to, either the data subject, whether it be a housing authority, for example, the housing records management system you use, safeguarding systems that you might use, the 4 or 5 systems you use, because that would represent the 95 to probably in some cases 99% of records you hold around an individual. I work, for example, you may know, I work 1 day a week in the accident and emergency department at the Royal Devon Exeter Hospital as a senior healthcare assistant, and we use a great system, a great system which now records everyone's data on. No more paper records, no more big files. It's all on one system. Patient comes into the front end. X-rays, scans get put on there, blood results get on there, COVID swabs get put on there, safeguarding issues get put on there, observations get put on there. A one-stop shop, a really great it's called Epic, a really great system to be able to do so. And if, for an example, in 20 years' time, somebody who and I'm on shift tomorrow, someone way on tomorrow, can you please provide all the information that we're able to supply? Well, the answer is yes, because we can actually give you your own log on, so you can actually read all your documents. So we don't have to supply it. Fantastic. So in my policy at the Royal Devon Exeter Hospital, I would say up until the 1st of October to 2020 when the system was introduced. Up until then, there are a number of manual structured data, and here is my manual structured data, and here are the files that you can access with relatively easy, and I believe they're in scope, and here are the computerized records, which I believe are in scope, and I will only be searching those as my reasonable and proportionate search. So right at the start, the person making the subject access request knows what's reasonable and proportionate. They know what your policy is. They know what your challenge is, and they know what to do if they want to require more information. Now, you might say, well, that's not fulfilling the obligations of the legislation. Well, it is, because courts have said, in the eyes of the legislator, there needs to be a balance. You know, data protection law is not about an absolute all in favour of the subject requester. There is a balance. You shouldn't do an undue burden of undue burden on the controller. There also needs to be a balance in releasing information about third parties, and ultimately, if those exemptions which apply in the legislation, which could be used against a subject access request, are there because Parliament has decided that there is a significant public interest in not releasing that information. So it's a balance between the two. So a policy is actually very clear at saying, here are the 5 top systems I'm going to interrogate. Here are the manual documents I'm going to interrogate. Beyond that, we don't consider them to be reasonably proportionate. So,
Yeah.
So I've just seen a chat. I've just seen a chat pop up, and I want everything. Well, hang on. But if you haven't defined in your policy what you think reasonable proportionate is, then you can't blame the employees, can you? Really, for asking for the information. I want everything. Yeah. Well, what do you really want? What's reasonable proportionate? And you can do that up front. And there's absolutely nothing wrong with that whatsoever. Because ultimately, if someone appeals to the Information Commissioner, the first thing they're asking you to do is release the information, aren't they? Unless you have a justifiable reason. You know, one of the things that people get scared about the Information Commissioner in terms of some of the challenges you get, but the Information Commissioner are great. If you work with them, they understand some of the challenges. And if you have a policy, quite clearly, remember that your DPO, if you're a DPO sat on the court, for example, remember that Article 39(1), one of your tasks is not only to ensure compliance to the law, but is also to imply compliance to your own policies. If you don't have a policy, how can you comply with it? So my advice to you would be actually, you get yourself a policy up. And Natalie, I feel really generous today. I feel really generous today that if people would like a copy of a draft subject access request policy, which lists out those areas which you might want to study, then if you contact Meg or whoever does the supervisory bit to the thing, I'm quite happy to share our template with you, because it's really good practice.
Yeah, brilliant. And just to highlight what you said there, Nigel, that's really not just talking about subject access requests there, we're talking about compliance with the transparency as well, where it's across the board, and that necessary and proportionate is something that we see throughout GDPR. And so I'm conscious that we are getting towards the end of 45 minutes. So is there any sort of final words from you, maybe a recent court case or anything that you'd like to finish up with?
Yeah, so ladies and gents, I would urge you, just I'm a geek, and if you've got nothing else to do, you all got lots to do, I'm sure, but have a quick look at the Dawson Damer versus Taylor Leasing case, which went to the Court of Appeal in 2020 March. It sort of got lost in the fog of the early days of lockdown. We're all panicking. There's an awful lot there. It's a very dull case about trust law. So I'm just looking at the case now, and certainly certainly paragraphs 1 to 55 is a really dull piece about trust law. Forget that. Unless you're really interested, I would suggest you don't look at that. Thank you very much, David Morris. I would suggest you look from 55 onwards, really. And it sort of reinforces what I've just said around manual unstructured data. And it also reinforces the point about, if you said to me, Natalie, what's the first thing I do when I get a subject access request in and look at the data? Well, one, is it personal data? Two, is it readily available? Three, are there third parties involved, and do I have a common law duty of confidentiality to them, or a legislative duty of confidentiality? And four, if I release this information, is it going to harm anyone? A, the individuals who's requesting, or B, some of those people maybe work in the organisation or made judgments at a time. And five, the last bit of advice I can give Nats is really work with the data subject. And that's what this case is really interesting, because it actually really really highlights the need to work with an individual, not necessarily examine their motives to a degree, because to a degree subject access requests are motive free, and however, once again, those people involved in EIR or FOI law, you know, certainly if things are malicious or vexatious, then you clearly can apply an exemption around that, or exemption to personal data stored in it. So my advice would be what's happening in the world. Certainly the television case, and it's quite interesting. And I've got one final question there. There's one final question came in the chat box. I'll do that, Natalie, and then we can close it down. Yeah, death by Nigel, otherwise. By the way, does everyone like Eddie Jones? Eddie Jones is joining us today. He's I tried to liven up my background, and I thought Eddie Jones. We're going to try and have a new one each week, so I'm not quite sure he's going to be there next week. Right, Sean. No, he's still sulking, Robert. After he's still sulking after Saturday. I wish to know. Yes, yeah, Sean, yeah, certainly. In the challenge you've got is around the self-harm test, isn't it, Sean? In terms of medical records. And does the NHS and GP subscribe to this? Most probably no. But the openness, the Access to Medical Reports Act has been in place since, let me get this right, since the late 80s, am I right? Oh, 90s, yeah, late 80s. So it's been around for a long time. My opinion is, does the NHS and GDP subscribe to this? Some do, some don't. But the interesting thing that you can find on Epic, which is MyCare, it's called, the system we're using in the hospitals now, Sean, is that patients can see everything. Whereas before, you might think about redacting documents, particularly around mental health, for example, or for example, sexual health, or for example, opinions that individuals have given. But if, for example, it forms a narrative to how someone, for example, let's say, for example, Sean, there was a narrative there whereby someone ended up in a secure unit, for example, because of judgments made by clinicians over a period of time, and that individual was trying to understand how they got there, then clearly, surely the intention of the law would be that information should understand how they got there. And so, do they subscribe? I don't know. I suspect some of them do, some of them don't. Should they, Sean? Answer yes, in my opinion. However, we have got to balance this up, haven't we? We have really got to balance it up, particularly around whistleblowing, particularly around, for example, harassment cases and those sort of things. Ladies and gentlemen, thank you very much. Natalie, anything else?
No, there's no final words from me. I think maybe just to highlight the key points that you've made today about context, necessary and proportionate, and the temp test, I think I'm right in saying, are probably our 3 take-homes. Yeah,
and so if people want to find the temp test, the best way of doing it is looking at televising and going to paragraph. I'll tell them exactly where they'll go. Paragraph 79 in televising. So David Morris, as ever, Richard's, yeah, Robert's found it as well. Yeah,
I do.
Yeah.
And as much, we've still got comments coming in, and it would be great to talk about exemptions, but I'm conscious we're already eating away into people's time. So maybe a conversation for another day, Nigel.
I think that's another day. I can bore the pants off Eddie Jones. He loves the exemptions conversation. Yeah. Thanks very much, everyone. Good luck with the subject access requests. I know that you've got a lot to deal with, and keep safe. We are, as the Prime Minister says, we are reaching the light at the end of the tunnel, and enjoy your work.
Brilliant. Thank you very much, Nigel.
Thank you.